Good evening, Mr. and Mrs. America, and all the ships at sea. I was thinking this week about the current state of the work culture in the good old USA, and particularly just how debased it is, and how the supposed protector of all American workers is a complete and total joke. Allow this rag and stuffing prognosticator to offer a bit of history of something we know today as the Equal Employment Opportunity Commission, or EEOC as it is better known. 61 years ago, President Lyndon B. Johnson signed into law the Civil Rights Act of 1964. One section of the act, referred to as Title VII, prohibits employment discrimination based on race, sex, color, religion, and national origin. The act applies to private employers, labor unions, and employment agencies. The act also creates the Equal Employment Opportunity Commission, or EEOC, to enforce Title VII and eliminate unlawful employment discrimination. Only 3 years later, Congress passed the Age Discrimination in Employment Act of 1967, or ADEA, protecting individuals who are between 40 and 65 years of age from discrimination in employment. Originally, the Department of Labor, not the EEOC, had enforcement responsibilities for this. A bit later on, President George H.W. Bush signed into law the Americans with Disabilities Act of 1990, or ADA. EEOC was given responsibility for enforcing Title I of the ADA, which prohibits private employers, state and local governments, unions, and employment agencies from discriminating against people with disabilities in employment. Title I did not, however, become effective until 2 years after President Bush signed the bill into law, or July 26 of 1992. And now, friends and colleagues, here we are 33 years after that, and this puppet can officially declare that the fantasy of the federal and state governments actually protecting your supposed or imaginary rights is over. First up, you are limited to 180 days to file a charge of discrimination. Now that sounds like a lot of time, but in reality it is not. You have people who have been traumatized complete with PTSD and are essentially shell-shocked from the abuses endured at their employer, and they have to gather their senses, try to recollect each and every essential detail of the horrors they just endured, and write it all down on paper before any of it fades even a bit from their memory. While you may be thinking this puppet is exaggerating in that description, think again. The days of respectful and well-intentioned employers are largely over in the United States of America. Yes, I know that some companies are ran by genuinely nice individuals, but suffice it to say that far too much of the employment landscape has been ravaged by cutthroat sadists. So say you get your complete testimony documented on paper and we are ready to file your case with the Equal Employment Opportunity Commission. Great. You're ready to get justice, you're overdue. Hold up there, Padre. Not so fast, my friend. You see, aunts and uncles, the supposedly protective EEOC does not allow you to file a case against any U.S. employer until you first contact an attorney in your state and get said attorney to accept your case. And if you live in a state like so many do, the EEOC attorneys are so backlogged with clients that you are much more likely to get declined than you are to get accepted. Okay. After calling 20 attorneys in your state, you're fortunate enough to actually get one to accept your case. Great. Yay. Let the court proceedings roll. Not so fast, my friend. What happens next is that the attorney needs upfront fees paid for in advance to file documents with the EEOC, and often they are beyond the financial capabilities of people who just got shortchanged on their salary by ruthless employers. So you have a friend or relative who can lend you the upfront attorney filing fees, and you are ready, set, and loaded to go. The next thing will be sitting through interviews and depositions that seemingly never end as your attorney and the EEOC go back and forth. And finally, after all of that, kids and cousins, you're more than likely to receive a letter of declination from the vaunted protector of employee rights, even if you have the most rock-solid case in a long time. Suffice it to say that if you are not of African ancestry or female gender, your case is almost guaranteed to get declined by the EEOC on first filing by your attorney. You know, white men cannot be discriminated against. It is impossible, right? What does a person do at this juncture, you ask? Well, after the EEOC declines your case, you are now free to sue the employer directly. So your attorney then initiates discussions with the employer, seeing that if an out-of-court settlement can be agreed upon. This process takes sometimes years to play out, During that time, there will be documents to file, testimony to repeat ad nauseum, and letters to write. And after all of that, the former employer can either agree to an out-of-court settlement or will insist on a trial instead. That, however, is the more rare option. And so, my viewers, after things have progressed to the point of a financial settlement, you will be required to sign a confidentiality agreement whereby you agree to never divulge the case to anyone nor the actual monetary amount awarded to you. So, my friends, I think it is safe to state that it works out sweetly for the offending employers as they can proceed on with their ritual abuse of employees, the overall public relatively unaware. As such, more and more victims get sucked into their dungeons of pain, and relatively very few have the gumption, patience, and stamina to stay the course for multiple years and make their abusers pay. The federal government set it up this way willingly and purposely, and the states largely love this arrangement because it allows the narcissist abusers to go on unabated in their crimes and abuse patterns. Capitalism is all about keeping innocent victims strapped to their hamster wheel, and as such, there need to be myriad hamster wheels available. And from all of that, friends and colleagues, I believe you can see why the EEOC, quote, protections, unquote, are largely a joke. This is also what abusive employers bank on. The fact that even if they serially discriminate against you for any of the EEOC protected classifications, the process of obtaining actual justice for the abused employees is purposely so intricate and lengthy in nature that many will simply give up trying or die before it can ever pay out to themselves or their families. The system, quite literally, is stacked in the favor of the corrupt corporate overlords, and oh, by the way, all labor unions were broken and done away with decades ago, so the Chinification of the American workforce continues unrestrained under the complete serfdom of the American populace. And that, my friends, should concern each and every one of us. Good night, my loyal viewers, and sleep well.